Welcome to today's webinar, Legal Fundamentals for Blockchain Startups. I'm Gabby Ababa, Growth Marketing at Atrium, and your moderator for today's webinar. A few logistics before we get started. This webinar will be roughly 45 minutes of content and Q&A. You can submit questions at any point during the webinar on the left side of your screen. Today we have two great Atrium attorneys who specialize in servicing startups in the blockchain space, Amy and Collins. I'll let them kick it off by introducing themselves and then dive right into the content.
Thanks, Gabby. I'm Amy Liu. My background is in private equity. Out of law school, I spent 4 years at Ropes & Gray in Boston and Hong Kong, where I mainly represented private equity firms in purchasing and selling multi-million-dollar, sometimes multi-billion-dollar companies. Most immediate to Atrium, I spent a little over half a year working for a boutique law firm in the Cayman Islands, advising virtual currency projects and investors from around the world. And here at Atrium, most of my clients are in the fintech and blockchain space, as I serve as outside general counsel to startups in various stages of fundraising and development.
Hey, good morning, everyone. This is Collins. My background here is as a corporate and transactional attorney focused on working with startup and high-growth tech companies, primarily fintech and blockchain companies. I began my career at Wilson Sonsini, which was one of Silicon Valley's leading big law firms for technology and high-growth companies, where I focused on both private and public company representation in a number of corporate securities law and regulatory capacities. There, because of my personal background in virtual currency, I gravitated towards a number of fintech and blockchain companies, and I joined Atrium Fintech and Blockchain as the first attorney hire about a year and a half ago, trying to bring my expertise to bear for startups and growth companies that leverage blockchain and other DLT in their daily operations.
So, what is Atrium? Well, Atrium is a full-service startup corporate law firm that uses modern technology to deliver legal services that are fast, transparent, and price predictable. Founded by Justin Kahn and backed by Andreessen Horowitz, YC, General Catalyst, and other investors, we're trusted by over 400 of the top startups and hyper-growth companies in and outside of Silicon Valley. Collins and I are on the fintech and blockchain team, where we represent clients in all stages, from very early seed stage to unicorns. On this slide, you'll find a few of our clients, which we've been given permission to disclose. So today we're here to talk about fundamental considerations for all blockchain startups. Today we'll discuss the high-level considerations under each of these four categories. 1, forming a company or not, and we'll get into what that means shortly. 2, service providers and incentives, considerations for forming your team. 3, fundraising and legal considerations in the U.S. And 4, regulatory strategy considerations when building your product or company.
One thing we want to be clear on here is that this is really meant to be something that addresses a number of the concerns that our entrepreneurs raise to us on a day-to-day basis. It's not comprehensive and is by no means exhaustive. As many of you are probably aware, this is a space kind of fraught with regulations and a lot of complexity here. So take from it what you will, and feel free to ask any questions if you'd like us to focus on anything in particular.
Great, so let's jump right in. Forming a company or not. So you have an idea. What's the next step? Well, it depends on what your goals are. Do you want to run a business to make money? Do you want to create a nonprofit organization that will return funds to the community? Or do you want to create an uncensored, decentralized protocol and release it to the world? The goals are important to determining whether or not you need a legal entity. And if you do need an entity, then it will inform the type chosen and the jurisdiction that's set up in. As discussed, a threshold issue is whether or not you need to form an entity. Bitcoin is the most successful blockchain project that's been built to date, and there's no entity behind it. There are a couple of reasons for this, and people have argued this extensively. However, one thing that has contributed to its success is arguably the lack of formal entity that is subject to regulatory challenges and scrutiny. Now, there are other risks associated with having no corporate form, particularly because replicating Bitcoin's immaculate conception is arguably impossible in today's world. Regardless, the following are types of things that will be really important for you to consider. 1, censorship resistance. An identifiable form and principles are subject to regulatory action and potential enforcement. And a centralized entity serves as a central point of failure that can ultimately be censored by governments and other stakeholders. 2, regulatory scrutiny. Related to censorship considerations, there are certain risks of centralization dependency, including giving regulators an entity to scrutinize and pressure. Separate from legal considerations, business-wise, you might want to consider the risks and dependency on centralized aspects of your business, even if it is overall decentralized. For example, Dependency on third-party cloud storage is a related risk. 3. Perception and expectation setting in public. What's your mission? If it is charitable or nonprofit driven, a foundation or other non-corporate form which requires or is biased towards profit maximization may not be appropriate. Examples of this outside the U.S. include the Atrium Foundation. And 4, capital allocation and need for future funding development efforts. Oftentimes, investors dictate what type of entity you need. For example, Y Combinator requires almost all of its portfolio companies to be Delaware C Corps. Along the same lines, if you're raising money from traditional VCs, we often have a handful of select corporate forms and jurisdictions that they prefer you set up in.
So there are 2 other things that are listed here that are also critically important. One, as Amy alluded to, is a real question about the need for limited liability when you're thinking about forming a corporate organization. If you're thinking about forming any type of business or even nonprofit organization, one of the best ways to shield yourselves and protect your personal assets is to select a corporate form that gives you limited liability. Depending on that form, it can be something like a corporation, a limited liability company, or even something like a foundation or trust, depending on your jurisdiction. But generally, what these things aim to do is limit your personal liability to the amount that you've invested in the venture or the entire enterprise itself if faced with an insolvency type of situation. Now, there are some exceptions to this, instances like fraud, piercing the corporate veil if you've been using the corporate account as your personal piggy bank. Having director and officer liability if you serve in one of those capacities may also mean that you've got some additional liability. But in general, there's a real question about whether what you're working on warrants a limited liability form in order to protect yourselves. And we'll get into some of the reasons why that is in a bit. Lastly, tax is obviously the thing that drives many, many business decisions, and it's particularly important in virtual currency businesses, especially because we note that a lot of the entrepreneurs and individuals that we deal with don't typically have this top of mind, but it often is a gating item, prohibiting them to moving on to other transactions or other representative deals that they'd like to do. Now, in many places, you also need to understand that you may not be able to qualify for certain things like a nonprofit status solely by virtue of working on blockchain activity, even if it seems interesting or educational or scientific. And generally in the U.S., there's also been some scrutiny on blockchain entities here trying to get special treatment as a nonprofit entity or some other type of alternative entity. In general, this is one of the few things that really needs to be drilled down on as you're forming a company and as you're going and engaging into certain business transactions in order to make sure that you guys are protecting the company and, most importantly, maximizing your ability to use your operating capital.
Okay, so if you decide to form an entity, the next question is where? It's important to think through some of these considerations on this slide. We just talked about corporate form and the importance of limited liability. Does the jurisdiction that you're looking at offer these structures and protections under their law? How settled is their law with regards to the virtual currency industry? As you've seen with the U.S., regulatory uncertainty can hamper business operations and decision-making. So sometimes it is better to go to a jurisdiction with defined laws regarding virtual currencies or have sandbox constructs to build out an MVP before launching in the U.S., if at all. Tax implications for all the stakeholders is an important consideration, especially the treatment of sales, capital gains, income, and VAT, and the nexus between that jurisdiction that you're looking at and the founder or other stakeholders' tax resident jurisdiction. In relation to regulatory clarity, does the jurisdiction have laws that may require registration or licensing? For example, in the U.S., securities need to be registered or fall within an exemption to be offered to the public. And as we'll see, if you plan to move funds around as a business, you may need money transmitter licenses, both federally and by state. Some licensing schemes can be more burdensome in terms of time and money than others. And lastly, with all that said, you should consider whether you actually want to move to that jurisdiction if needed. Is it easy for you to get to and possibly for your investors to get to? You need to be there in person to set up banking, regulatory, legal, and administrative relationships. Further, will allow you to reach your target audience. On this slide, you'll see some of the most popular jurisdictions to set up in, depending on your goals, as discussed. The Cayman Islands is a favorable tax jurisdiction, which attracts sophisticated international investors. Singapore is also an attractive jurisdiction for investors and planning teams, given its strategic geographic positioning in Asia and favorable virtual currency regulations, as evidenced by its regulatory sandbox. Switzerland is similar to Singapore in that its regulators have been more forthcoming with virtual currency guidance, and it acts as the financial hub of the world, made famous by its concentration of banks and strict bank secrecy laws. And lastly, while there is regulatory uncertainty in the U.S., if you plan to fundraise from U.S. investors, market to U.S. end users, or interact with the U.S. in any substantial way, you may end up subject to its laws anyways. Given its centrality to venture capital funding and general capital formation, it still remains one of the best jurisdictions in the world to attract investment, talent, and to quickly scale a new enterprise. I'll now turn it over to Collins, who will discuss service providers, incentives, and fundraising strategies.
Thanks, Amy. And before we hop to the next slide, one thing that we should definitely mention, turning away from the formation of a company, is that for anyone thinking of not forming an entity for some of the reasons that may have been listed or some other considerations, it's critically important to understand that that is not a shield from liability and may actually open you up to unlimited and personal liability. The decision to not incorporate should not be made lightly. You should at least advise yourselves from counsel as to what those implications are, particularly because some of these jurisdictions that Amy just noted may treat things very differently. For instance, in the U.S., an unincorporated organization or somebody acting without a corporate form typically may be exposed to significant liability. So please keep that in mind as you all consider the types of entity or whether you'll have an entity at all. And next, we move on to service providers and incentives. And obviously, once you formed a company, one of the things that next has to occur is creating a team. And sometimes there's already an existing founder and or co-founder team. Sometimes they're immediately looking to scale up. But in general, these are some of the more important decisions that our founders and startups grapple with on a daily basis once the companies are in existence, since obviously motivating a workforce or developers to continue to develop on a platform can be really important to see the success of a project or an enterprise. So some of the things that are important, and again, note that these are not exhaustive, but are really the things that tend to come up over and over for a number of our startups, are some of the things that we have listed on these slides here. So one major thing that many blockchain companies face, particularly because they're global entities, are understanding classification needs both within the U.S. and outside of that, and what that may mean for your business. Many countries, including the U.S. and other countries in the EU, really pay attention and are increasingly focused on properly classifying employees or independent contractors. Outside of the U.S., this can be particularly important since many other countries have statutory rights that extend far beyond the rights that U.S. individuals enjoy, including the lack of not having an at-will employment framework or other types of frameworks that may not be well understood by entrepreneurs here in the States. Other things are incentive mechanisms. So on the traditional basis, you have your equity compensation, things like traditional equity grants, options, profit interest in LLCs, RSUs, et cetera. But there are also obviously virtual currency incentives and a number of virtual currency companies, whether those are tokens, some right to participate in the future distribution, or something similar. Both of these have a number of regulatory and securities law considerations, with equity compensation being fairly well understood given its history. Virtual currency incentives, on the other hand, can be a little more complex and involve some of the same regulatory uncertainty that's present in some of the token distributions that some of you may be familiar with. Other things that also matter here are trying to structure the vesting or the distribution of incentives in ways that ensure long-term engagement and engaged participation from service providers. And that can be both with equity as well as certain types of virtual currency incentivization schemes. If the idea is that you'd like certain types of individuals or developers to be working on and investing in your project long term. And finally, as is the case with forming a company, tax issues are always going to be fairly important, particularly for employees or contractors that have income tax implications from receiving or having distributions made to them of virtual currency or equity distributions. So some of the type of service provider incentives that we see fairly frequently can largely be broken down into three broad categories, two of which are probably familiar with many people that have started startups before, and the last is something that's fairly unique to virtual currency and cryptocurrency businesses. So restricted stock awards are your standard stock grants, which often work really well when the company is very young, just strictly as a direct grant to the individuals. They'll own the stock outright, and those people can vote their shares and do a number of other things, even if they're subject to vesting. Keep in mind, as a company matures, direct grants tend to fall away in favor of something like options, which gives the employee or an independent contractor the right to purchase options at a particular price at a certain future point at the company's life cycle. Now, in these instances, service providers don't own the stock outright. And something not listed here, but just something that you guys may have heard floating around before, are concepts like RSUs, which tend to kick in at an even later stage for companies, which operate in some ways akin to both a stock grant and an option. But we'll forego that discussion for now, since that's a little outside of the scope of most early stage companies. Finally, you've got the things that are fairly unique to virtual currency companies, which are we've broadly classified here as virtual currency grants. But these kind of range. It's everything from direct token grants, options on tokens, if there's ever a token distribution, restricted top token units under token compensation plans. And then there are, some even more exotic flavors that we're starting to see emerge. Things like employees that are entitled to certain portions of a founder's reward that's inherent into a protocol, or a number of other approaches that remain and continue to be seen. I think the important thing to kind of keep in mind here is that regardless of what type of incentive you're using, you need to both weigh the regulatory and legal implications along with the business considerations and practical implications that are going to be important for your workforce, and ensures that they're actually motivated and excited to work on your project and come into work every day. So, we'll move into fundraising now. And fundraising is obviously one of the things probably nearest and dearest to a lot of people's hearts, since it's the thing that is both most well known and gets a lot of people excited. And obviously fundraising can take a number of different forms, particularly with virtual currency companies, as I'm sure almost everybody listening to this already knows. So let's just jump directly into things here. So again, with financing, we've tried to simplify things as much as possible. And we've broken this down into three broad categories. Traditional financing, which we're considering things like your priced equity rounds, along with things like convertible instruments, safes, notes, et cetera, and even things like debt, venture debt, traditional debt, et cetera. We're skeptical, but if you can find a traditional large institution to just give you a loan for a blockchain company, please send them our way, as I'm sure many of you have struggled with your banking partnerships. On your token distribution side, you have things like your ICOs, your STOs, initial exchange offerings, and the host of other different types of acronyms and distribution forms that people are probably familiar with. And lastly, in more recent times, even though there's arguably precedent from the earlier days of crypto, we have these emerging patronage models. Early models are things like the Ethereum Foundation grants, Zcash Foundation, and other grants. But more recently, we're starting to see permutations of this with things like the Model DAO grants and other types of decentralized organizations that are setting up infrastructure that ideally sets up a means of some of these open source projects having long-term engagement and funding mechanisms. So here, what we really wanted to present on this side in the next few minutes are just some broad thoughts and considerations for the types of distributions and financing mechanisms that we just raised. And in particular, you'll see if you're following along on your computer or later pull up the slide, we've taken those three breakdowns and further broken them down into what they tend to be, how they're accomplished, both in terms of private or public offerings, certain securities laws exemptions are commonly used, and then the types of instruments that are pretty commonly used. While we won't read through the slide directly, at a high level, we'll just touch on each of these really quickly, as we think they're important for folks to understand, and sometimes these things can get muddied. So on the equity side, these are, in the simplest form, people can think of them as, priced equity rounds. And these are things like your Series A or B or C rounds. They typically occur either on a private placement. Some people know these as Reg D offerings, but there are a number of other exemptions like Reg S offerings for issues outside of the U.S. And you also have what we call kind of public and or retail-enabled offerings. Public offerings are what most people are familiar with when a company either goes public on the stock market or has a public offering. Retail-enabled offerings are things like what we deem, Reg A plus or Reg CF. And the reason why we highlight this here is that, a number of folks consider these things as public offerings, but it's important to understand that these are actually exemptions, for securities law registration requirements that allow retail investors to participate. And that's important because it has some distinctions and additional restrictions that public offerings, aren't typically subject to. These types of distributions or financings are typically accomplished with your stock purchase agreements, subscription agreements, or in the public offering case, standard public offering documents or purchase exchanges. On your convertible instrument side, they're fairly similar to equity rounds, but for the fact that these are things like your safes or notes, they can still occur with your private placement offerings and other securities law exemptions on the private placement side. And there are also these public or retail enabled offerings, although it's typically less common for convertible notes to be issued in the public setting, except with respect to corporate bonds that are far beyond the scope of this discussion for your average startup here. As mentioned, those instruments are things like your safes and convertible notes. Finally, we've got kind of the broad world of token distributions. And these are, everything from token sales to airdrops, lock drops, and other virtual currency style distributions. These can be accomplished in a manner of ways if things are being issued under the securities laws. The private placement, exemptions are available to folks, as well as some of those public offering or retail enabled offerings. Many people may be familiar with some of the recent Reg A Plus listings of Blockstack and Props, as well as some of the folks that have gotten no action letters from the SEC to sell or distribute their tokens as non-security assets or distributions. And then, of course, there are folks that have decided to forego issuances within the U.S. While trying to navigate the regulatory landscape here. One thing that is critically important to understand, because it's something that we see over and over, is merely excluding U.S. folks, whether you're inside of the U.S. or outside of it, may not be enough to take you outside of the U.S. securities law framework. And in particular, what we mean by that are, there are certain restrictions for things that are potentially securities from flowing back into the U.S., as well as certain things that the SEC may impute to owners of foreign subsidiaries here in the States. And in both of those instances, the mere fact that users have agreed not to distribute tokens back into the States or sell tokens to U.S. purchasers may not be enough if those transactions still continue to occur. So in the instances where you are thinking about token distributions outside of the States, it's important to try to consult with counsel, understand what the requirements are there, and make sure you really understand what that implicates, because it's terrible to have folks go outside and later realize, oh, this was not actually achieving what we intended it to do. And these instruments for these types of distributions vary extremely broadly. You have things like token purchase agreements that mirror stock purchase agreements. There are convertible instruments like the SAFT or SAFETs or other things. There are the traditional mechanisms, or as traditional as you get in crypto, and your 2017 days where people really just relied on the smart contract logic to distribute tokens. There are so many different ways and permutations that these things can take. There's no real, form that we can highlight here for you, but hopefully this gives you a sense of the types of things that you should be thinking about, things that you need to be considering. And the last thing we'll say on this slide is that, in general, when making the decisions between these, some of the considerations that you need to think about are things like how much time you have and the resources that are available to you to pursue these options, whether you can meet, certain disclosure and reporting requirements, who your investors are and who your end users are, and whether that type of distribution currently allows for the type of velocity and movement within a digital asset if you are distributing one of those in a way that actually comports with how you want the platform to actually operate.
All right, regulatory strategy. So we've given you a lot to consider in terms of setting up a company, providing incentives for your service providers, and the many different ways to fundraise. An overarching consideration is what laws can potentially govern all of these matters, including your business and its operations. We'll dig into that here. One of the threshold questions to your regulatory analysis is your token or coin a security? Or is the fundraising strategy that you're deploying causing you to be distributing unregistered securities in violation of Federal Securities Act? If so, there may be a host of implications, such as restrictions on how you sell, public or private sale, and on what platform, who you sell to, restrictions on accredited investors or not, disclosures during sale, AML KYC requirements, what you can say, and corresponding transfer restrictions if your virtual currency is found to be a security. The predominant federal test is the Howey test, which looks at 4 prongs. 1, was there an investment of money? 2, in a common enterprise? 3, with the expectation of profits? And 4, from the efforts of others. All 4 prongs of this test have to be satisfied for the token or coin to be a security. States also have securities law regimes that may or may not align with the federal scheme. For example, California employs a different test known as the risk capital test, which looks for factors such as whether investors have the power to affect the success of the enterprise and whether the investor's capital is at risk. A few other important notes to point out on this slide. Airdrops may or may not be considered unregistered distribution of securities. If you're receiving value from the end user, that may trigger securities implications. For example, if an end user is giving you their time or non-monetary resources, or even an email for marketing purposes. Another point is that if your token or coin is found to be a security, that not only impacts how you make the initial distribution, but also sets forth transfer restrictions on future token or coin holders that may create friction if your business model depends on the seamless exchange of tokens or coins between end users. And lastly, even if you operate a quote-unquote decentralized platform, such as an exchange, there are centralized actors or an administrator that maintains and provides instrumental functions, such as a centralized order book maintained on a central server. Then you may also be subject to securities laws.
So, we'll touch on commodities laws here, and this is, of the three major regulatory regimes that tend to, apply to our crypto companies, one of the ones that tends to be covered, the least. But these are important, particularly because the definition of a commodity is fairly broad under U.S. law and essentially covers everything that's not a security. Now, one of the threshold questions here is, are you dealing with regulated commodity interests? And these are typically futures, swaps, or retail commodity transactions, which are usually defined as transactions that are, finance leverage or on a margin basis with, the counterparty and the counterparty at hand. That's shorthand here, but it's something that a number of people are probably familiar with some of the DeFi platforms that are starting to emerge. And there are certain exceptions to those rules, including, actual delivery of assets underlying these transactions that motivates some of the things some of you may be familiar with, such as, those 28-day delivery requirements on some of these decentralized platforms. Regardless, if you have a certain commodity interest, like one of these interests, you may be triggering commodities law registration requirements and other requirements. And some of those implications include things like registering as a designated contract market, a futures commission merchant, or some other type of regulated entity that engages, in transactions with regulated commodity interests. The Commodities Futures Trading Commission, which is kind of the governing body that enforces commodities law here in the U.S., also does have some authority over spot markets, for fraud and market manipulation. And when we say, spot markets, what we mean by that is, primarily transactions in which the asset is actually delivered at the time of payment by, the purchaser. Now, when we look at those, one important thing to also understand, and something that's emerging that a number of attorneys are keeping an eye on, is the CFTC's increasing focus on things like insider trading. That's become a renewed focus in the past few years, and they've modeled their insider trading after federal securities laws. This is important because a number of people, on Twitter and other various forums that are quite popular with the crypto community tend to engage in certain activities that would typically be discouraged in a securities law setting. And a lot of those folks have taken the position that, these aren't securities and these things aren't implicated in certain statements, don't trigger potential liability. Understand that the CFTC has made it a new focus to start enforcing things like insider trading and anti-fraud generally in the commodities markets, but in particular, they've also started to focus more heavily on cryptocurrency and blockchain businesses. So keep this in mind, and while it's esoteric, there are probably some good examples that some of you are familiar with, starting with Bitfinex and why certain, offerings for Bitfinex were not available to U.S. individuals prior to their closure here in the States.
Okay. Money service business and money transmission laws are generally triggered if you are accepting and transmitting currency, monetary instruments, or something that substitutes for these instruments, whether it be fiat or convertible virtual currency, from one location or person to another location or person. For example, centralized virtual currency exchanges generally qualify as money transmitters because they can accept funds into hosted wallets on behalf of users and transmit them to other users or locations. There are federal money service business and money transmission laws, as well as state laws that often mirror the federal framework. There are certain exceptions to the application of these laws, at least on a federal level. These may include whether you provide money transmission services ancillary to your provision of other goods and services that is not money transmission itself. As well, if you're merely acting as a developer of code that's providing the delivery, communication, or network access services used by a money transmitter to support money transmission services, you may not be a money transmitter, as long as you are not also undertaking such services yourself. That said, all states do not have similar exceptions, so consulting with counsel is critical here. If you're found to be performing money transmission services and do not fall within an exclusion or exception, then you'll have to register federally and by state where your activities are held and end users are affected. The registration and creation of compliance programs can be an expensive and time-consuming process, and if you think that your business may trigger money transmission implications, we strongly suggest you speak with an attorney sooner than later, because there are all sorts of Bank Secrecy Act requirements, such as KYC and AML obligations and compliance program that you'll have to implement.
Great. So, that wraps the initial part of this presentation, with some closing words here. In general, starting a blockchain or DLT company is very similar to starting, many other startups, and we try to encourage people to think of themselves first as a particular type of company and not solely as a blockchain company. Just like in traditional industries, there aren't Excel companies or Notion companies. You have your gaming companies, you have SaaS companies, and they employ certain technologies. The same is true for many of you guys as entrepreneurs. And so thinking about that from that perspective may help to reframe and color your perspective when you're starting to grapple with some of the same issues that a standard Silicon Valley or really any global emerging business is dealing with. But along with that realization is the fact that you do have some particular regulatory obligations or other considerations that are unique to this industry. These can be extremely complex, really nuanced, and just requires a lot of thoughtfulness. One of the best ways in which you can avoid foot faults and, more importantly, significant product delays is trying to get good advisors, lawyers, tax folks, anyone that's relevant for you guys making critical business decisions, engaged as soon as possible and as early as possible in the product development cycle. If you can do that, they can help you look around corners ideally and hopefully avoid some of the backtracking that some folks have had to do very publicly in certain instances. In this instance, we think that something that encourages you and a model that encourages you to engage with your service providers is something that you should primarily be prioritizing if this is something that is going to be critical to you and ongoing discussions are going to be important for you on a day-to-day basis. With that, we'll stop here and we'll move into the Q&A section of the presentation. So feel free to reach out, ask any questions here, and we've got another 10 to 15 minutes. We're happy to respond to questions from the audience on. Great, and we'll give it another 30 seconds or so. If there are no additional questions, we're happy to wrap up early here and we'll let folks go. If anyone's struggling to enter any questions, you'll notice on your web browser there's a section called Q&A, and that's where you can type in questions. Otherwise, we're happy to let folks go a little early. We'll give it to about 10:35 and then we'll wrap here.
Okay, well, that wraps us up. Thank you all so much for tuning in, and thank you, Amy and Collins. If you do have any additional questions, feel free to email events@atrium.co, and we can try to get Amy and Collins to answer for you. We'll also be sending out a recording of this webinar along with the presentation for on-demand viewing, and so you can share with your colleagues. Have a great day.